Hello viewers, I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. My topic is Child Labour and Human Right. Children are the greatest gift to humanity, and childhood is an important and impressionable stage of human development as it holds the potential to the future development of any society. Children who are brought up in an environment which is conducive to their intellectual, physical and social health grow up to be responsible and productive members of the society. Every nation links its future with the present status of its children. By performing works when they are too young for the task, children unduly reduce their present welfare or their future income earning capabilities, either by shrinking their future external choices set or by reducing their own future individual productive capabilities. Under extreme economic distress, children are forced to forego educational opportunities and take up jobs which are mostly exploitative as they are usually underpaid and engaged in hazardous conditions. Parents decide to send their child for engaging in a job as a desperate measure due to poor economic conditions. It is therefore no wonder that poor households predominantly send their children to work in early ages of their life. History of child labor. Child labor is not a new problem or experience. It has existed in every part of the world since ancient times. In more recent history, it emerged as an issue during the Industrial Revolution when children were forced to work in dangerous conditions for up to 12 hours a day. In 1860, 50% of children in England between the age of 5 and 15 years were working. In 1919, the world began to address the issue of child labor and the International Labour Organization adopted standards to eliminate it. Throughout the 20th century, a number of legally binding agreements and international conventions were adopted. But in spite of these, child labor continues to this day. Concept of child labor in India. Child labor in India is a human rights issue for the whole world. It is a serious and extensive problem with many children under the age of 14 working in carpet making factories, glass blowing units and making firewoods with bare little hands. According to the data given by Indian government, there are 20 million child laborers in the country, while other agencies claim that it is 50 million. The situation of child laborers in India is desperate. Children work for 8 hours at a stretch with only a small break for meals. The meals are also frugal and the children are ill-nourished. Most of the migrant children who cannot go home sleep at their workplace, which is very bad for their health and development. 75% of the Indian population still resides in rural areas and are very poor. Children in rural families who are ailing with poverty perceive their children as an income-generating resource to supplement the family income. Parents sacrifice their children's education to the growing needs of their younger siblings in such families and view them as wage earners for the entire clan. Child labor is a conspicuous problem in India. Its prevalence is evident in the child's work participation rate, which is more than that of other developing countries. Poverty is the reason for child labor in India. The major income of the child laborer is also observed by the families. The paucity of the organized banking in the rural areas create a void in taking facilities, forcing poor families to push their children in the harsh labor, the harshest being bonded labor. Factors leading to child labor. But what leads to child labor? The answer can be obtained from the following points. Less income of the family leads to child labor. The child is forced to work and earn at a very lower age. It becomes a compulsion for them to work and earn livelihood for themselves and their families. Thus, a child for the sake of his family is compelled to work in several places. Ignorance of parents towards education result in the lack of education of child and he have no other options but to work and earn his living. children are found to be better producers of certain products such as knotted carpets and other such kind of goods. Hence, these children are hired and exploited to work and produce such type of goods. This is known as nimble finger theory. Discrimination on the grounds including gender, race or religion also plays its part in why some children work at such a tender age. Child trafficking is another cause of child labor. A number of children are brought and sold and are exploited to work as laborers, beggars, domestic workers, etc. In domestic matters, children can be made to work easily and at a low wage. Moreover, the masters can dominate them easily. Thus, the number of children working in households constitute the major part of child labor. However, across the world, millions of children do extremely hazardous work in harmful conditions, putting their health, education, personal and social development, and even their lives at risk. Legislative provision on child labor in India. The Constitution of India 1950 came into effect from 26 January 1950, introduced a revolutionary chapter on the rights of the child. The framer of the Indian Constitution incorporated various important provisions for the betterment for the children. In view of the dictum, children are the wealth of a nation. The constitutional provisions are expressly or impliedly, directly or indirectly related with the protection of childhood, child education and elimination of child labor system, which are as follow. Protection guaranteed under Article 15 Clause 3. According to Article 15 Clause 3, the state can make special provisions for children. It shows the concern of the framer of the Constitution that the state strives to promote the welfare of the children without any discrimination. It means the founding fathers add this positive provision enabling the state to make law for the welfare of the children and to give them preferential treatment over other persons in the society. The object to incarnate Article 15 Clause 3 is to avoid any controversy and demonstrate the concern of the framers of the Constitution that the state shall strive to promote the welfare of the children. Frankly, admitting the solitude for the children and repulsion for the exploitation of children of tender age impelled that founding father to add such a specific positive provision enabling the state to make law for the welfare of children and to give them preferential treatment over the persons in society. Child's Right to Education Act Article 21. Article 21 is very much important article regarding children because while interpreting Article 21, Supreme Court in 1993 has declared right to education is a fundamental right. The Constitutional 86th Amendment Act 2002 added a new Article 21A which makes education is a fundamental right for all children between ages 6 to 18. Actually, Child Labor and Prohibition Act 1986 does not talk about the complete prohibition of the child labor. Rather, it regulates child labor in certain premises, and Article 21 is talking about compulsory schooling. And if Article 21 is read with Child Labor Act, both cannot move together. So, it is better to amend Child Labor and Prohibition Act in the light of Article 21. Right against exploitation, Article 23 Clause 1. Although Article 23 Clause 1 does not specifically speak of children, yet it is applied to them and is more relevant in their context because children are the most valuable section of the society. It is a known fact that many children are exploited even by the parents who allow their exploitation because of their poverty, and in absence of parents, their exploitation by a close relative still deeper. They are deprived of the education, made to do all sorts of work injurious to their health and personality. It is clearly designed to protect the individual not only against state but also against other private citizens. Article 23 is not limited in its interpretation against the state, but it prohibits traffic in human beings and other similar form of forced labor wherever they are found. Labor or services which are a person is forced to give without receiving any remuneration for it is only a form of forced labor. Protection under Article 24. Under Article 24, The Constitution of India makes a loud assertion for the protection of tender-aged minors and gives them a fundamental right of education and well-being. It says, in People's Union of Democratic Right versus Union of India, the Supreme Court held that though the Employment of Child Act 1938 did not include the construction work on projects because the construction industry was not a process specified in the schedule to the Act, yet such construction was hazardous occupation and under Article 24, children under 14 could not be employed in hazardous occupation. The right of a child against exploitation under Article 24 was enforceable even in the absence of implementing legislation and in a public interest proceedings. Article 24, read with Article 21A, also read with various judgments of Supreme Court on right to education of children and about the prohibition of child labor, are totally violated by these legislation, as they permit the children to be employed in factories and other areas of work. Special protection under directive principles of state policy. Initially, it was thought that DPS enshrined in Part 4 was merely a pious obligation on the part of state and that could not be enforced in any courts. Article 37 itself states that these articles are not enforceable in any courts, but nevertheless, the principles laid down therein are fundamental in the governance of the country, and it was felt that it was the duty of the state to apply these principles in making laws. Article 39 clause E and F direct the state to evolve a policy eliminating the abuse of tender age to free children from the circumstances forcing them to enter into a vocation unsuited to their age or strength. The state is also directed to create social and economic conditions and infrastructure for the healthy development of children and maintenance of dignity. The state is further directed to protect the children against exploitation and moral and material abandonment. The Supreme Court in Sheila Barseh v. Union of India held that Article 39 Clause F of the Constitution provides that the state shall direct the policy towards securing the goal that children are given opportunities and facilities to develop in a healthy manner and in condition of freedom and dignity, and the childhood and youth are protected against exploitation and against moral and material abandonment. The Supreme Court further stated that though various states have enacted Children Act for the fulfillment of constitutional obligation for welfare of the children under Article 19 Clause F, yet it is not enforced in some states, and the court directed that such beneficial statute should be brought into force and administered without delay. Under Article 45, a duty is imposed upon the state to provide free and compulsory education within a period of 10 years of the commencement of the Constitution for all the children until they complete the age of 14 years. The directive principle signifies that it is not only confined to primary education but extends to free education, whatever it may be, upon the age of 14 years. Article 45 is thus supplementary to Article 24 on the ground that when the child is not to be employed before the age of 14 years, he is to be kept occupied in some educational institution. Article 45 provides compulsory and free education for children up to age of 14 years. One of the objectives of these articles is that the state should provide free and compulsory education to all. Legislative framework on child labor. It was also decided that both the union government and the state government could legislate on matters concerning child labor. Various legislative initiatives were also taken in this regard at both the state and union level. The main legislative measures at the national level are the Child Labour Prohibition and Regulation Act 2016. In July 2016, the Parliament has passed the Child Labour Prohibition and Regulation Amendment Bill 2016. This Act amends the Child Labour Prohibition and Regulation Act 1986 by widening its scope against child labour and provides for stricter punishment for violation. The 1986 Act prohibits employment of children below 14 years in 83 hazardous occupational process. Salient provisions of the Act. The Act has completely banned employment of children below 14 in all occupation and enterprises, except those run by his or her own family, provided that education does not hampered. The 1986 Act prohibits the employment of children under 14 years in certain occupations like beadi making, mines, domestic works, power looms, automobile workshop, carpet weaving, etc. Addition of a new category of persons called adolescent. It defines children between 14 to 18 years as adolescents and bars their employment in any hazardous occupation. The Act makes child labor a cognizable offence. Employing children below 14 years will attract a jail term between 6 months to 2 years or a penalty between 20,000 to 50,000 rupees or both for the first time. Repeat offenders will attract imprisonment between 1 year to 3 years. In case the offender is a parent, it provides a relaxed penal provision and proposes a fine of rupees 10,000 for repeat offence committed by a parent. The Act has the provision of creating rehabilitation fund for the rehabilitation of children. The number of hazardous occupations has been brought down from 83 to 3. The 3 occupations are mining, inflammable substances, and hazardous processes under the Factories Act. It empowers union government to add or omit any hazardous occupation from the list included in the Act. The Factories Act 1948. Under the significant provision, the Factories Act expressly prohibits child labor against exploitation. It is nothing but a protection granted to the child laborers. Employment of child less than the age of 14 years in any factory is prohibited under the Act. The law has provisions for pre-adults between the age group of 15 to 18 years employed in any factory about who, when and how long employment is done. No child can be allowed lubricating or adjusting any part of machine clean which exposes to the risk of injury to young person of any adjacent machinery from any moving part of that machine, and all this mentioned in section 22 of the Act. No child can be allowed to employ on hazardous machine defined under section 23 of the Act. Employment of child in industries for pressing cotton in which a cotton opener is used is prohibited under section 27 of the Act. Minimum Wages Act 1948. Towards the minimum time rate of wages, there is a fixation by the state government. It also assured time rates of payment for different industries and minimum pieces rate of wages and children, adolescents and apprentice, locality of class of work and adult through is a mixed fixation. The Mines Act 1952. The working of child less than the age of 18 years in a mine, the Act prohibits. The child shall be there in any part of mine, or neither they shall work in any open cast in which any mining operations are carried out. Recommendation to stop child labor. To curb the social evil of child labor, the following are some of the suggestions. Citizen Watch Citizen can volunteer and inform the right authorities if they notice child labor anywhere. Government can announce awards to whistle-blower to encourage the practice. Media campaign. When communities were small, people probably refrained from committing crimes due to the fear of social boycott. If media publishes information of wrongdoers, others may stop from such act. Education. The elimination of child labor is interlinked with the provision of full-time formal and quality education provided free to all. Many children do not have a choice but to work because there is no well-functioning educational system available or because they are not stimulated to attend education. During the Industrial Revolution, it was possible to eliminate child labor in Europe due to a combined mandate of prohibiting child labor and implementing compulsory education. This should also happen in developing countries. Special attention to girls. 2/3 of all children that are not going to school are girls. The work that they perform is often hardly visible in one's own or someone else's household. This work is denying these girl children their right to education. The backward position of girl children is a consequence from the belief that girls do not need to be educated because they will become housewives anyway. In some communities, girl children drop out of school early because of child marriages. Moreover, girl children are often taken out of school because it is considered inappropriate and dangerous to walk long distances to school. At the moment, there is a fortunate more attention for the arrears of girls in their participation at basic education. This should, however, be tied to an equal attention for the hidden work of the girls that is often the largest obstacle to their participation at full-time education. Conclusion: it can be concluded that children constitute the nation's valuable human resources. The future well-being of the nation depends on how its children grow and develop. The great poet Milton said, "Child shows the man as morning shows the day." Children are the future custodian and torch-bearer of the society. They are the messenger of our knowledge. Unfortunately, millions of children are deprived of their childhood and right to education, and thereby they are subjected to exploitation and abuse. Child labor exists in India, notwithstanding the laudable provisions of the Constitution and laws addressing the child labor. So at the end we can say it is duty of the society to look after every child with a view to assuring full development of its personality and curb the evil problem of the child labor. See you in the next lecture. Thank you very much. Till then, goodbye.